Fani Willis gets hit with a new appeal from our friend Harrison Floyd. Harrison Floyd, you remember on our channel some time ago, we covered the bond revocation hearing. Harrison was posting on X, and Fani didn't like that, said being very dangerous by exposing all of the corruption in her office and in this case. And of course, she wanted to throw him back in jail and filed a motion to revoke his bond. We had this ridiculous hearing. Fani came out. She thought she was like a Hollywood, hero, and was doing all this performative stuff, sitting down, standing up. Like, what are you doing, Fani? Have you ever been in court before? And it was really kind of embarrassing. The judge said, well, Fani, he didn't have any notice about was it allowed or not allowed under the protective order. And so how about we just give him a warning on this? And then if he does it again, then we can talk about sanctions for that, right? So Fani's like, well, Your Honor, I object. Someone's going to get killed, right? Very hysterical, very dramatic. She might actually have been putting on a show for her lover, who was seated right next to her, which we didn't know at the time was actually her lover. So that's Harrison Floyd. And Jenna Ellis, who took a plea deal in this case, sent a letter in when Harrison Floyd was trying to remain out of custody, and Jenna Ellis supported Fani Willis in putting Harrison Floyd back in custody. We remember that as well. We're not forgetting that. So Harrison Floyd is here, and he is now appealing in Georgia, and he files this motion. He's requesting a certificate for immediate review so that he can take this up to the next level in the Court of Appeals there in Georgia. And he can't do that yet until he gets permission from the lower level judge. This is going to be the spineless Scott McAfee, the judge who said that what he saw from Fani Willis had an odor of mendacity, but apparently he couldn't put his finger on where that odor was coming from, such that it required Fani to be booted from the case. 2 bank robbers, one of them's okay, but 2 bank robbers is bad. One can stay, Fani Willis stayed. Okay. So Scott McAfee now has to grant permission to Harrison Floyd to take this up to the next level, and this is a different issue. Now, Harrison has already attempted this several times, as we're going to see in his filing. This is Harrison Floyd filing in the Superior Court of Fulton County in the state of Georgia. Big Fani Willis is the prosecutor in this case. And as you can see, this is defendant Harrison Floyd's motion for a certificate of immediate review. This is permission to appeal this up to the higher level court. Here is what Floyd's attorneys say, and you can see not a too significant filing, too long. Todd Harding, attorney for Harrison Floyd, and Christopher Kacharoff, both there representing Mr. Floyd. Here is what they say in their motion. All right, Your Honor, Scott, comes now defendant Harrison Floyd, by and through his attorneys who filed this motion for certification of the court's order. You denied reconsideration of our prior motion that was entered back on 3/14 for immediate review. Okay, so let's break down there what is going on. So denying a reconsideration, which means they already filed something that was denied. They asked for a reconsideration, which was denied again. And so now they're appealing the denial of the reconsideration. Just so we're like multiple layers deep here. Okay, so Floyd has already made a similar request before. They say here, the defendant, called Harrison, filed his plea in bar, and we're going to substitute the concept of a motion to dismiss for this phrase. Plea in bar, barring the charges, a motion to suppress all of the evidence. It is a motion to dismiss. We're trying to bar this case from moving forward. We filed this back on October 31st, 2023. And back when we filed this, Your Honor, we asserted that Fani Willis, this is back in October, right? So this is way before any of this explosive Fani Wade, Fani Willis, hibbity-dibbity indictment nonsense was going on between the two of them at 4 in the morning when he was, getting off the cell phone with her saying, I'm home, baby, all that stuff. So they filed this before any of this broke, because all that just broke relatively recently, early January, saying that at the outset, Fani did not have authority to investigate or to bring election-related charges against Harrison Floyd absent a referral, see here it is, from the State Election Board, here after called the SEB. So in other words, Fani cannot do anything. She can't bring charges on election-related matters absent a referral from the election-related board. She's just a prosecutor, right? Her jurisdiction is for criminal charges that emanate from statutory violations that have already been codified in the law. The state election board, they may do some investigation here. They may take a look at this and say, we think there was a crime here. Now, we, as the state election board, we don't have the authority ourselves to bring criminal cases, to prosecute crimes, but somebody else does, and Fani does, and so we're going to refer it over to you. So the defense says it is undisputed here that no referral was sought by Fani. She didn't go to them, nor was any referral granted by the SEB. The state filed their response after we submitted this in November, and they said, we don't need a referral, right? Fani turned around and said, we don't need a referral from the SEB. We can do whatever we want. I'm the biggest Fani in Georgia. Don't you know who I am? I can do whatever I want all the time with no consequences. I'll see you later. I'm going on a cruise. Don't bother me, okay? Don't text me. I'm going to be gone for a week. That they had concurrent jurisdiction with the SEB, right? So they go, well, they do have jurisdiction, but so do we. And so it is overlapping with one another. They're not separate. So in other words, it's not like the SEB is over here and Fani's over here, and they observe a violation. They make a referral over to Fani. No. It's like they're basically overlapping in some way. So this is Fani's and this is the SEB's. And so it's right here. So you don't need a referral from one to the other because they already have jurisdiction. Says this court, so the defendant here, Harrison, filed his reply that counters those claims back on December 14th. Said you don't have concurrent jurisdiction. This is how the law works, not this, Fani. So they issued that response. And the court denied Harrison's attempt to end this case. Okay, so in other words, this case is over. If Fani doesn't have jurisdiction, if this is the requirement and this referral never happened, then everything that Fani has been done illegally. She's got no basis to be here. So they said, all right, well, the court denied our plea in bar. That was earlier this year, January. And they found that Judge McAfee says, yeah, we do find that there is concurrent jurisdiction, despite no authority to be found for such a decision. Where the heck did that come from, Judge? Haven't heard that before. Do you have any case law for that? So they're wanting to know where it came from. Now, on January 12th, so just a few short months ago this year, the defense, Harrison Floyd, filed for a certificate of immediate review, or in the alternative, a motion to reconsider. So again, back then, they wanted one of the two things to happen just 2 months ago. Immediate review to take it up to the next level for the denial, or for a motion to reconsider. Now, the court denied Harrison's motion on March 14th and affirmed its prior order and denied the plea in bar, the motion to dismiss for lack of prosecutorial jurisdiction. So that was denied. And it sounds like the judge treated this as a motion to reconsider rather than as a motion for a certificate of immediate review, right? So the judge treated it as a motion to reconsider. Oops, sorry guys, no, motion to reconsider denied. So now, right after all of that procedural history, now we're back. And they say, as grounds for this motion, now Harrison Floyd respectfully shows, Your Honor, that a certificate of review is of such importance to the case now that the immediate review should be had in the Georgia appellate courts. And specifically, an immediate appeal would assist you, judge, so-called, and the parties in determining the applications of Georgia law to very specific rules of Georgia law, right? So we've got these two provisions. Georgia law 21-235, 15-12-100. There's probably going to be a conflict between these two laws. The issues presented in Harrison's motion to dismiss the plea in bar are issues of first impression in the context of election-related cases. So Georgia's never seen anything like this before, and so we only have little case law on point for guidance that we can look to explain what's going on here. Now, in support of this motion, they say the defense shows this court the following. And so they're saying Scott McAfee, that's kind of the background for this. They're going to give us some case law, and we'll see what it says before we get into some analysis. They say, all right, here, Judge, the general rule in Georgia is that all parts of a statute should be harmonized and given sensible and intelligent effect, because it's not presumed that the legislature intended to enact meaningless language. So if you've got two statutes that are at odds, they feel like they're at odds with one another, you should try to harmonize them. And the courts should not just write stuff out of the rules and just say, well, the legislature is just idiots, even though they are. They wrote it in there, so we should presume by default that they wanted it there. Now, Georgia courts also say that a statute, so when legislature passes a law, it turns into a statute. When we read it, it must be construed in relation to other statutes of which it is a part. And all statutes that are relating to the same subject matter, briefly called statutes in para materia, right? So statutes like in a web of context, are construed together and they're harmonized whenever possible so as to ascertain the legislative intendment and to give effect thereto. So try to make it work as best you can, right? We know our Congress, our legislators are, largely incompetent. And so they're going to have a lot of difficulty in creating statutes that are harmonized. But courts, when you're making your analysis, you can apply it accordingly. They say American jurisprudence also holds, so American law holds that words or texts of statutes matter. Thomas Cooley, in a treatise on American law, wrote this: the courts must lean in favor of a construction that will render every word operative rather than one that makes some idle and nugatory. There's your word of the day, nugatory. I don't even know if that's how you pronounce it, but that's how we're pronouncing it, all right? Nugatory. You don't want nugatory language in your writing. So if your statutes are problematic, try to construct them in a way that is harmonized across the board, right? Saying here, defendant in this case now asserts that the court erred in failing to recognize that this statute is a specific statute that overrides the provisions of this statute. It's pretty clear. So if they wrote it, right, if they wrote this statute with words in it, we have to give those words and that phrase meaning and effect. We don't want nugatory words in there. Sheesh. Now, to be sure, Fulton County DA Fani, they say she does have broad powers. It's true. But in an election-related case, which of course this is, those powers in elections are clearly statutorily limited without a referral from the election board. And you might want to have it that way, right? You might want to have a different body decide whether or not a hack prosecutor can bring hack prosecutor charges in election cases, right? So that you don't have situations like we have now, where you just have one whack job DA with unbridled power who just decides she's going to make a name for herself and bring criminal charges against political opponents to the state. So they say she's limited, right? That kind of makes sense. Now, despite this court's explanation of harmony, Scott McAfee, the judge, says that there was harmony among these statutes and that Fani does hold concurrent jurisdiction, so Kamala's Venn diagram, with the SEB, and that a referral from the SEB to Fani is not necessary in election-related cases. And so and they're saying, look, Judge, if that's your holding, if you say they already are in harmony, then this law is absolutely meaningless. It's superfluous. It's totally irrelevant, right? This law is saying that this is why we exist. This is why this law exists, is to enable the referral process from the SEB over to Fani. So if you decide, Judge, that there is concurrent jurisdiction based on Lord knows what, then this is not useful. And we can't say that statutes are not useful because that would disenfranchise the legislature, who is elected by the people who put that statute into effect. Now, the Georgia legislature, they tell us, has provided concurrent jurisdiction, so the overlapping jurisdiction, 194 times. They went through, someone did the counting, that intern. Like, okay, hey, go take the highlighter and just go through the statutes. What? All of them? All of them. You know, the statute books are like, you see all those books up there? Some intern, he's going through 194 times. I'm just kidding. 194 times in particular areas throughout the Georgia Code. Yet there is no mention, not one, of concurrent jurisdiction found within this statute, 21-235. By allowing for concurrent jurisdiction, which says that the SEB and Fani can, do the same thing within the Georgia Code that many times, so they know how to do it, right? By allowing them to do this, they've done it 194 times. They know how to do it. They're not dumb. If the Georgia legislature actually intended that Fani should have concurrent jurisdiction with the SEB, they know how to state that. They know how to write it in there. Now, by not writing it in there, by omitting it, it is clear that the Georgia legislature did not intend for the DA to act unilaterally without the SEB's involvement, because maybe they turn into partisan hack prosecutions, just like the one we're living through now. Now, the text of the statute is clear that the Georgia legislature intended a referral from the SEB before a DA can take action on the case. And here, Fani got no referral at all. No referral was given to Big Willis. Therefore, the Fani usurped the power that was given to the SEB. They make that decision before it goes over to her. Usurped the power given to the SEB by the Georgia legislature, and now Fani is pursuing her own agenda without any statutory authority to override the SEB. So she just took it and ran with it. Was not entitled to do that, because that's just what Fani does. Now they continue and close this out saying there is little case law, Your Honor, Judge, on this particular case. So this renders the subject a case of first impression. No one's ever decided this before. Now, there exists a conflict between these two statutes, 21-235 and 15-12-100. And the court's explanation, Scott, of harmony between the statutes fails to reconcile the application of these statutes. There is no harmony. And as such, this court should therefore allow the guidance of the Georgia Court of Appeals to decide the issue. Now, very interesting case, right? Very interesting little nugget. And there clearly appears to be some nuggetory language that we have some concerns about in this entire case now. But this is curious. And it seems like the judge does not want this issue to work its way up. So as a reminder, we've already seen they made the motion, denied, a motion for reconsideration, denied. Now we're at the permission to appeal, the motion for reconsideration, which was the denial. So I'm not so sure that McAfee is going to want to grant permission to appeal this portion of this case. I have a feeling that he'll deny this and say this issue is clear and moot, but I'm hopeful that he does not, right? This would be a very good issue because it would moot and disqualify Fani Willis from the very beginning. If she is trying to usurp state authority by prosecuting this case, claiming concurrent jurisdiction when she in fact does not, that is a fatal flaw, right? It means that everything from the beginning, from the initial investigation through the impaneling of the original grand jury, it's all done unlawfully and illegally. And so it sounds like a good argument. We'll see what Fani Willis says in response to this and what Scott McAfee does. But if his history is any guide, well, I don't think he's going to do much on it. And so we've got reaction here from Trump acting attorney general for a brief bit after, I believe, Jeff Sessions resigned. We had Matthew Whitaker step up at the White House, and he had some thoughts on what's happening there against Trump, not only in Georgia, but across the board, saying, this is weaponization of all these institutions against the former president, and explaining how he thinks this is going to go down.
I think they will say it's a ridiculous case. I think they are also had two considerations. Even though they didn't write an opinion when they reduced this amount and gave them another 10 days, I think the two things on their mind were that there's no way that the $450 million judgment is going to stand under the law. It was unrelated and untethered to any actual damage amount. There were no victims, and it was based on loans that were repaid in full with interest. I think the second issue they had was the legitimacy of the New York courts. And quite frankly, international businesses and really all businesses looking at doing business in New York thinking that they can be arbitrary and capricious with anybody doing business and start grabbing assets whenever they want after the Attorney General targets them. So I think there were a couple considerations. I think ultimately this case gets tossed out because it's a ridiculous outcome.
Well, Matt, I think another thing here is the timing of the case. We've had guests on that say, it goes to the appellate court here, defense, the prosecutors, they make their arguments here. That might happen after the election. So if Letitia James's goal is to, impede the campaign of former President Trump, which it looks like she is here, that may not happen now. They all are. They're doing it everywhere. It might not happen until after the election. What do you think?
Yeah, I think you're right. Where have the Democrats focused a lot of their effort? It is in places like New York and D.C., solid blue base.
And Georgia, Fulton County, very, very blue, as we saw, 73% for Joe Biden.
For them, both the Attorney General of New York and the Manhattan prosecutor decided to use their power to pursue just absolutely illegal actions against President Trump because they could, and that is an abuse of power. It's an abuse of the legal system. And, again, I think ultimately this all gets fixed. But to your point, Bob, it doesn't get fixed before the election, and it ends up being election interference because it paints a narrative that just is inconsistent with actual facts.
Right, and it consumes the media. Right, you may not be in Fulton County or Atlanta. Right, I'm not there. I am not in Georgia, Florida, DC, New York, but the local media, the local energy, right? Every time there's these court proceedings, it captures attention and that amplifies interest in the case. And, depending on how you view this, right? Some might say that any news is good news, right? No, there is no bad news and it's bringing attention to you. But on the other hand, right, it's creating energy. I think for an already blue demographic, it's causing people to be, instigated into action, maybe donate money. And it causes Trump a lot of opportunity cost in terms of time, in terms of his money. He's got to come out of pocket to defend all this stuff. And so, we'll wake up and look at some of these states and there will be shenanigans in the states. It's not going to be, like a clean cut election. I can virtually guarantee that, where we just wake up. Hopefully it is. It's 48 states. Trump sweeps it or something. But unlikely that that's going to be the case. And when we're zooming in, asking ourselves what happened in that state or what happened in that state, if it doesn't go our way, right, we're going to clearly point back to this. It's tens of millions. It will be hundreds of millions of government money that was spent to stop Donald Trump just in the courts of law. And they'll say it's all justified, but we know better than that. So does Matt Whitaker.
But Matt, we have been seeing former President Trump actually getting a boost from a lot of these trials. And, it seems that people are sick of the politicization that they've seen.
We are sick of
this.
it.
Do you think that could actually help the former president, even though these will not be resolved before the election?
Yeah, I think essentially people are seeing this for what it is, which is a completely crazy pursuit of one individual because of their political beliefs. And, Donald Trump, I'm sure, is feeling pretty good today because, his stock went public. He's made about $1.5 billion today alone.
Not bad.
And, these legal cases are starting to fall apart against him. And so I think that is what you're going to see as we head into November. But the weaponization continues. And I think the pursuit of Donald Trump to try to do anything but beat him at the ballot box is what the left continues to pursue.
Yeah, and they're freaked, right? Which is why they're pulling out all the stops. And there are apparently new investigations in Arizona and elsewhere, so we'll see if there is another shoe to drop. But Harrison Floyd submits that motion to appeal Fani Willis, saying that she is just not authorized to even be in charge of this case. Everything from the original investigation on should be dismissed because her jurisdiction is non-existent and she didn't get a referral from the elections board. So that's from Harrison Floyd. Of course, he is on X and he could use your follow, use your support. And I know he's crowdfunding to help support his defense. So make sure you're following him and supporting him if you can. But we'll be here continuing to cover this and seeing what the government says in response to this, and then obviously what Judge McAfee says, whether he grants this or not. We'll be covering it. So thanks for joining us as we do, my friends. Thanks for subscribing wherever it is you're watching this. Thanks for liking this video. Thanks for inviting someone you know or love to come over here and join us. We got some amazing links down in the description below. If you want to sign up for our daily newsletter or read the PDFs that we cover here, robertgovea.com. Link down below is where you can do that. We have an amazing members-only community at watchingthewatchers.locals.com. We'd love to see you there for our morning streams and our Saturday streams. And we'll be back here to see you back here on the next one.